Hi everyone, my name is Dhruv Sharma and I am a probation officer with the Office of Juvenile Justice Services here in Calcasieu Parish. And I just wanted to go over three court cases that are especially relevant to my field right now. And there are three cases that I think will define this field going forward in a time where a lot of changes are happening right now in juvenile justice. Um, right now I work at the Multi-Age Resource Center, which is called the MARC or the MARC Center, which is next to our main juvenile detention center where we handle primarily youth on pretrial diversion. Um, Other responsibilities that we have are like home detention checks for kids who are on supervised release, such as home detention or ankle monitors. We also handle other stuff, extraneous stuff like school referrals and walk-in complaints from families that just need help for their children. And we also do handle court cases. Um, in our department, we have two court officers who go to court every day that there's court, and we usually have it Monday, Wednesday, and Friday, who represent children who are not yet on formal probation, but who have been charged and are going through the process right now. They handle their cases and present to the judge and converse with the attorneys on how to move forward. And with recent months, a lot of changes have come in the juvenile justice system, especially regarding probation and diversion, which is what I do for the most part. I do formal diversion. And I just want to go over a couple of cases that it pertains to. The first one, and one that it doesn't quite affect um, probation work, but it does set an important precedent, is the court case United States versus Rahimi, which was in 2023. So this was last year. Um, it made it all the way to Supreme Court because of its volatile, very politically charged nature, and it dealt with gun rights. In 2022, in New York, they passed a law that expanded the gun ownership rights for a lot of people. And what this law was sweeping, it was life changing, and they demanded that in the law, the case law stated that it was retroactive. So it challenged several longstanding laws, and one law was prohibiting gun ownership by those who have domestic violence related restraining orders against them. That basically means that people who have those restraining orders are either limited in what they can own gun wise or they just can't own guns at all. Which it seems to make sense. However, a lot of people challenged it, saying that, well, domestic violence and guns aren't quite related. So the challenge made it to the Supreme Court because a man named, I believe it's pronounced Zaki Rahimi, um, alleged that it infringed on the Second Amendment rights because of the new law in 2022. Now, in June of this year, actually, the case came out in 2023, but in June of this year was when they finally ruled on it. They ruled 8-1 against Rahimi, which is shocking. I expected it to be a bit more partisan, but it stated that the statute was not unconstitutional because those who are deemed to pose a real threat, such as people with domestic violence restraining orders, because they had to be determined by a court to pose a real threat, a significant threat enough to have a restraining order taken out against them, they can be subjected to such statutes that temporarily disarm them. Basically, meaning they are subject to the same laws of people who are actually charged and convicted of crimes that require them to be temporarily barred from owning guns. Now, with my job as a probation officer, this ruling is not so much about what the issue was, but more so what precedent it set. It once again held up the idea that no matter, you know, what law comes around that changes the gun ownership rights, the nature of probation and restraining orders, any court ordered sanction, which probation is a sanction, comes with the loss of certain rights depending on the crime that you've committed. The logic that they used for the gun restriction laws for restraining orders is very similar to that for probation. For example, a juvenile who is convicted of, um, let's say, armed robbery with a gun, may in their probation or parole, whatever conditions, state that they're not allowed to own a gun. It seems quite obvious. However, this ruling in this court case kind of explains why it needs to be stated. Now, offenders on probation and parole are subjected normally to these type of conditions consistent with the crimes they've committed. Now, a person on diversion for a misdemeanor simple assault may not have that in their um, conditions that you can't have guns, but a person, adult, these are for adults, an adult who is convicted of aggravated assault with a firearm would definitely have a ban on firearms um in their what's the word for it, in their conditions for probation. Now, it with juveniles especially, this ruling kind of shows that you have to state it no matter how obvious you may think it is. It may be obvious that people with restraining orders are subject to the same court order sanctions that you would assume because they've been deemed a reasonable threat, but this court case shows that any challenge will be taken up. So with juvenile justice, we have to put in any condition for court cases as the most obvious rulings. For example, a person convicted of cyberstalking would not be allowed phone access. That has to be explicitly stated. And this case really just shows that you have to be obvious, you have to be redundant, you have to be more than more than obvious, more than detailed in describing these conditions because of this specific reason. You have to be specific, or any challenge would come your way. The second case that I want to talk about, it's a little bit more relevant now to Louisiana, is Mathena v. Malvo, and this happened back in 2019. And this is an especially interesting case because it happened, um, regarding it's a case involving a situation from 2002, where two juveniles, Lee Malvo and his accomplice, killed 10 people in Maryland. They were juveniles at the time. Or Malvo, at least, was a juvenile at the time. He was 17 years old at the time of the offense, and his accomplice was sentenced to death, but he was sentenced to life without parole. Now, in cases from 2012 and 2016, the Supreme Court ruled that it is unconstitutional, flat out, to sentence juveniles under 18 to life without parole. And it's saying that's a violation of the Eighth Amendment. It's cruel and unusual punishment. And in Montgomery versus Louisiana, the 2016 one, they ruled that this protection was retroactive. Therefore, this case came up as a retroactive case that needed to be vacated. They said that if a case that meets this condition needs to be vacated. Malvo appealed his sentence because of this ruling, and Supreme Court actually ruled in favor of him, and his sentence was vacated. Now, it upheld the Eighth Amendment again, saying that juveniles cannot be sentenced to life in prison, and this directly affects my job since we work with juveniles. And juveniles who come into our detention center for, let's say, first-degree murder or first-degree rape or anything serious premeditated crimes, you would expect them to face significant consequences. So what we have in our um, procedures and our laws is something called juvenile life. And juvenile life is normally stated until the age of 21. Normally, sometimes it's like age of 19 or 20. It is basically as many years as proportionate to the juvenile's crime, while also recognizing that they're juveniles and that they cannot be sentenced to proper life without prison. And I have not seen any cases that go beyond their 21st or 22nd even birthday, but it does exist every now and then. The scope of juvenile life has changed and it's a bit variable. However, the term is born out of these cases that juveniles cannot be sentenced to life, but we need a proportional sentence for significant, egregious crimes like first-degree murder, or like I mentioned, first-degree rape, that simple 6 months in jail would not suffice. Proportional punishment for the crime must continue. And this is a bit more tumultuous now because in April of this year, Louisiana repealed the raise the age law. So juveniles who are 17 are now considered adults, for the criminal justice system. Now, informally, for our like walk-ins with parents complaining about their children, or school referrals for fighting or vaping, um, they're still considered minors. But criminally, for criminal charges, they're now considered adults if they're 17 or older. And this has been a massive, major issue, with Mathena v. Malvo specifying juvenile life versus life in prison for adults. The issue of getting the age correct and the transition from treating all 17-year-olds as juveniles to treating them as adults has been rocky, and it continues to be rocky. In fact, any small typo on a piece of paper, such as stating their age wrong on a intake document would warrant calls to the director, to the law enforcement officials, direct supervisors chiming in, trying to make sure that you're not making a mistake. Because with these kind of rulings, like we got for Mathena v. Malvo, we can't just make a small clerical error because it is, in this case, the difference between literally life and death. You can't, obviously, we don't have death penalty for juveniles, we don't have currently life in prison for juveniles, but now that we've changed what a juvenile is, this case really shows that you can't mess that up. Of course, if we do mess it up, a judge would catch it, hopefully, and it would reflect badly on our department and our practices, and my job especially at the Multi-Age Resource Center because we handle all law enforcement calls. Any mistake of this caliber is on us because we handle all law enforcement calls, all first-time offenders. We're the catch-all for it. So these cases are always on our mind because if we make any mistake with them, we are basically stating that we're showing that we aren't up to date with the law. We're not up to date with anything, and our directors, our supervisors, they take the main hit because they're supposed to be in charge of us. They are held responsible. So Mathena v. Malvo being ruled in 2019, it's still relevant that it says age of 18 for juveniles. So of course, even this case is now getting outdated for Louisiana, especially. But we have to still follow the same type of rigid structure that it presents. The Eighth Amendment cannot be violated, and if we change the scope of what a juvenile is, we have to follow it, or it's on our heads. Especially at mine as the first contact, it's on our heads, and that is why this case is something that we have. This case and many others like it are things we have to keep an eye out, keep up to date with, because if anything changes with a case like this, or if it gets overturned, then well, we have to change our entire justice system again. The third and final case that I want to talk about, one that really affects my job almost on a daily basis, is Mott versus United States. This was also in 2019. And this case is a little bit special. It's it deals with the a person on probation, adults. This was a case about adults being incarcerated. What happens to their probation or parole while they're incarcerated? And the way the case handles it is the summary of the case is that give me apologize. Let me go ahead and pull up the document for the case. The case handles that Jason Mont, the offender, had been on supervised release for about 5 years or so for drug charges. It was federal, and he was in prison for some time because while he was on probation, he was imprisoned, tried, and convicted for a state offense. And while he was in prison, this was near the end of his probation, his supervised probation expired. His release was his probation expired on March 6th of 2017, and he was in prison until March 21st of 2017 when he got sentenced. This was his pretrial incarceration. His probation officer then informed the court that he violated his supervised release by committing the crime that got him in jail, and the court imposed an additional sentence for violating probation. And we do that as well in my job, where a juvenile that violates probation will face additional sanctions because not only did he commit a new crime, but in doing so, he violated a term of his probation, which is that you, and it's a blanket term for every type of probation or parole, you can't commit new crimes while on probation. The issue here was a bit complicated. It was a very roundabout case. Was the issue that Mont had was the jurisdiction. Like, why is this court suddenly telling me what to do? Their state court, I was in federal, but the Supreme Court did say straight up that the court exercised jurisdiction because his new conviction did violate his existing parole. The probation was for whatever time, and he committed a crime, which was a violation. So his appeal was denied, and it set an interesting precedent that supervised release is paused while incarcerated, but you can still exercise jurisdiction on ruling that they violated probation and then revoke said probation. Juvenile justice, we deal with this a lot. I work with pretrial diversion. We work with kids who are charged with misdemeanors and just smaller stuff. Um, we don't really deal with youth on a post adjudication basis. However, my colleagues in the field department do. And we all collectively have a precedent that this case directly influenced, which is that when um, when juveniles do unfortunately commit crimes while on post-adjudicated probation or on diversion with us, they are and are incarcerated, or even if not incarcerated, they're released to their parents or whatever, but they have the charges, it is considered a aggravating factor, and it's considered a violation of diversion or probation, and can result in the youth either being incarcerated or youth being sent to court and diversion being terminated because diversion is an alternative to court. And you think who are incarcerated have to be seen within the judge within seen by a judge within 72 hours, and it's normally at this time that probation is revoked or suspended and new offense is proceeded with. Now, our Calcasieu Parish system does things a little bit differently, where we suspend a sentence when we impose one for youth who have gone through the court system. When we impose, like, we will impose 2 years of probation on a child, but that would be 2 months of supervised release with said time in jail suspended. And we do so because it is a better representation of how probation works. You are allowed to be released on probation instead of serving jail time, so long as you don't commit anything else to warrant your return to jail. Any violation is an immediate return to jail. And in this case, directly influenced that. In this case, and many others like it, directly influenced that. We this does pose some issues with streamlining this system and keeping in touch with all the different departments. We deal with the DA's office a lot with this. However, it does show that when you have been on probation and you decide to violate it by committing a new crime, your probation doesn't just expire. It has to stop. You have to go through the process of this new charge, and then that probation will end, most likely being revoked because you have now violated. These three cases make up a lot of what we deal with on a daily basis, from the supervised releases to juvenile life, and of course, like I mentioned earlier, the need for redundancy, like in our agreements that we sign for diversion, we have to explicitly state, you can't break any laws, you can't hang out with youth with juvenile records, because it is, even though it's obvious that you shouldn't do that, by stating it, we are covering ourselves and complying with case law. And of course, if the youth has a gun charge or something, we have to put in there as a redundancy, you're not allowed to have any weapons, even though weapons are still, juveniles can't possess weapons anyway, but it's a redundancy that's necessary. These cases are these cases show that the leader takes the fall no matter what. If our department fails in any of this, the leader takes the fall. And that's why, as a good leader, we are supposed to keep up with case law, because if we don't, we expose ourselves to improper practices, doing our duties incorrectly, of course, and just not keeping in touch with how fast juvenile justice changes, given that it is a volatile and extremely um, politically charged field. So any day can come with new challenges. And that is my speech for today on these three cases. These three cases, of course, are one of some of many that have influenced this field and this job. And it's why we have court trainings every week. It's why we have to always check with each other before we make decisions. It's why supervisors are trained for months on end. And yeah, that is it for me. And I hope you guys have a good night.